The kitchen itself, as far as I understand it, the kitchen has been shrunk. Right now in the kitchen, there's some stainless steel sinks, some countertops, and a refrigerator. And to my knowledge, Lilac Acres LLC plans to use the kitchen only in accordance with the conditional use permit as approved. So caterers will come in, they'll store their food in the refrigerator, they'll use the sink, and they'll serve it, but there's no stoves going to be there. There won't be any full preparation of food in the kitchen itself. Mr. Chairman, so that's my findings in terms of the differences from the approved plans and what's actually built. Do you want me to talk about the potential amendment process, or do you want to wait to discuss those changes and we can get to that later?
Why don't we just hold there for a minute? There may be some questions. We'll pick that up later, okay? Maybe one of the...
Mr. Chairman, I have to make some preliminary comments.
Please.
I wish to remind everyone that this is a quasi-judicial matter. There can be no ex parte, contact. If you proceed to act on the quasi-judicial portions of it, that would be changes to the CU for sure, or termination of the CU. Changes to the plans may not be quasi-judicial. Those would be different. So, when he started to talk about it. So I have to warn you that what you say, you have to be very cautious, because you could make a statement or ask a question that then you will not participate in the deliberation as the judge. Okay, depending on what the deliberation is. That's just a fact. This is a very unique, I have never seen this, I've not discussed this with anyone, but I've not seen this presented in this manner before, because of you're the judge. And I don't know who the prosecutor is going to be if you proceed, but you'll have to deal with that. But you're the judge, so I have to at least warn you that you're the judge, and depending on what you say tonight might make that you give the impression you have a preconceived decision, and then you wouldn't be able to participate. Does that make sense?
Not completely to me. Can you maybe simplify that a bit? I'm not sure I get it.
Well, if you've already, due process requires that everyone be given a fair hearing. If the procedure for termination, and I know you didn't want to get into that, but this ties into it, a conditional use status will terminate when, after a public hearing, the Plan Commission determines any of the following, and then there are only 3 things that are the basis for a termination of a conditional use. So you have to base your decision on what's presented at a public hearing. And I'm not saying that we can't present facts tonight, and the owner of the property can't present facts tonight, but you can't give any comments or questions that would lead the petitioner or other members of the board that you've already made up your mind. That's the only way I can say it, because you can't prejudge the matter. You have to base your decisions on the public hearing if you're talking about a termination or an amendment to the CU. If you're talking about changes to the plans, and for those of you who know me, you know that I reference other things, and I can use Mr. Hamm he indicated that he was aware that there was a prior action where Mr. Butler came in and that was a change of a plan.
That was a change of the actual conditional use permit.
Okay.
So this could be different. There's a bunch of different options here, and we'll get into those after, I guess, but there's different levels of review and approvals depending on how you deem the modifications.
Yes, I have a question. First off, who are we supposed to be speaking with? Because this conditional use was approved to Ken Miller, DB, Lilac Acres owner, and we're speaking with a different owner now. So has it left hands of one and switched to another?
Well, I don't. If you're asking me, I don't think we're addressing this to anybody. The chairman asked for a report by the planner, and that's all we are at this juncture.
And I'm asking who we're supposed to be speaking with.
Well, the only thing I could add is that they're both representatives of Lilac Acres LLC, and so
It says right here in the conditional use limited to Ken Miller.
doing business as Lilac Acres, right?
Attorney Macy, are you advising members of the Planning Commission and Town Board not to ask any questions tonight?
I don't have a problem with asking questions if it's just to get facts as to the current status of the report that you've requested. But if you start, depending on how you ask the question, if you ask the question, well, that sounds like that's a violation of the CU, that sounds like you've prejudged the question. So yes, you can ask questions, but it's how you ask questions that might be used later in a court proceedings where the judge will say, your question was asked in such a manner that it's obvious you've already made up your mind.
Okay, second question, are you advising that we should not allow Mr. Jewell to speak this evening?
I am not advising that. If it's only as to the status of the plans, because most anybody in this situation could be coming in with a request to modify their plans. If we stick to the plans concept of it, I'm not as concerned. And I believe our planner's comments, as I listened to them, is there's only one issue that could be a potential CU amendment, and that would be the hours of operation.
Using the event house for overnight stays, hours of operation would be in conflict with the conditional use permit because it specifically lists what the hours are in there. It doesn't include overnight stays. So that would be different. Everything else I've listed in my mind has to do with the sets of plans that were approved, what the buildings look like, how the site lays out, etc. And so there is a provision in the conditional use permit that allows, if the plan commission determines the modifications to be minor, you can approve those without a public hearing, and so the plans get updated, they're still attached to the conditional use permit. If you don't consider them to be minor and major modifications that impact the use itself in a substantial way, then that requires a revision of the conditional use permit, requires a public hearing, etc.